It pleases everyone, so I'll start this session already. Distinguished colleagues, ladies and gentlemen, my name is Putri Sofia Amirnuddin. I'm the Program Director for Master of Laws Program at Taylor's Law School. On behalf of the Head of Taylor's Law School, Mr. Hamahinder Singh, who couldn't be with us today as he is currently in another virtual session, himself as well as myself, would like to extend our sincere appreciation as well as gratitude to our 4 distinguished panelists, as well as to all registered participants who are with us at this Taylor's online dialogue session. For the first time in history, the world has been watching coronavirus pandemic unfolding in real life. The COVID-19 pandemic is not just a health crisis, but it is rapidly imploding into business, economics, as well as societal crises. The United Nations Secretary General has shared that this is the worst crisis since the World War II. Similar sentiment has been shared by the IMF chief, who also mentioned that this is the worst crisis that IMF has ever seen. It takes about 18 to 24 months for scientists test, trial, approve, manufacture, as well as distribute effective treatment as well as vaccine. In the meantime, our very own medical doctors, nurses, as well as frontliners will work to the best of their abilities to treat COVID-19 patients. The implementation of the lockdown has suspended or decreased the rate of infection. Now, since lockdown has been relaxed, there are concerns with regards to the rate of infection, whether or not it will increase in the future. If it does, then the lockdown will be reintroduced. Then the intermittent pattern will be in continuation until the effective treatment and vaccine is made available to the public. While waiting for the effective treatment as well as vaccine, our medical doctors, nurses will work around the clock to provide continuous treatment to the COVID-19 patients. Despite their struggles, despite their sacrifices and efforts, there are concerns with regards to the medical, ethical, as well as legal issues in providing treatments to COVID-19 patients. It is hoped that our distinguished panelists will be able to provide their perspectives with regards to issues surrounding privacy, public health, as well as informed consent in light of pandemic. I will now pass this virtual floor to my colleague and also with the moderator of this session, to Dr. Ambika S. Turaisingam, who will introduce the panelists and thereafter moderate this session. Thank you.
Thank you, Ms. Sophia. Hello, everyone. I'm Ambi, and welcome to today's webinar entitled Challenges of Informed Consent During the Pandemic, Ethical Concerns versus the Legal Implications. In this exclusive live online dialogue event, experts will share their perspectives on issues surrounding privacy, public health, and informed consent in time of COVID-19 pandemic. Yeah. So as we know, disasters, emergency situations, and pandemic infections are occurring almost annually, and medical providers have been trained to obtain informed consent from patients to shield them from medical liability. Nevertheless, the COVID-19 pandemic represents an extreme challenge to medical frontliners as they are pressed to provide rapid emergency response to acute patients, and yet the climate of uncertainty during pandemic present barriers to them to obtain informed consent prior to a medical intervention. So medical doctors, nurses, as well as hospitals are faced with ethical decisions in the course of providing emergency treatments, and these decisions can have an impact on patients' life and affect how medical providers work. I would like to extend a warm welcome to the online webinar and to our panelists who have agreed to spend time with us this afternoon, namely Dr. Khor Kheng, physician and health system specialist, who will be addressing on how to balance personal privacy and public health during pandemics. Dr. Hui Siu, pediatrician and bioethicist, who will share her invaluable thoughts on informed consent and during the challenges during COVID-19 pandemic. Ms. Charlaine, Adrienne, partner at Messrs. Darryl and Law, who will discuss on informed consent, particularly the legal perspectives. Lastly but not least, Dato Dr. Patrick Tan Seow Koon, Anaesthesiologist and specialist in intensive care medicine. Ethical consideration in medical confidentiality would be his topic. Without further ado, I would now like to introduce our first presenter, Dr. Khor Siu Kheng. Dr. Khor, over to you.
Thank you, everyone, and thank you, Taylors, for inviting me to this session. I was thinking that yesterday or today there was this rankings that were released, and Taylors is the #1 private university in Malaysia according to the World University Ranking. So if that's factual, then I would say congratulations to everyone listening in, especially if you're part of Taylors. I like very much what Putri Sophia has said earlier to say that this pandemic is more than just a health crisis. It's also a social, political, economic, diplomatic crisis. And therefore, we need all of society to come in and, shall we say, share the responsibility of resolving this pandemic. And I'm glad that today we have a lot of doctors and lawyers, people who are interested in ethics and consent and also medical legal aspects of the practice of public health. And I'm glad that we can all come together today. The topic that was given to me is actually very large. Informed consent means many things to many different people. Pandemics means many different things to many different people. How to balance personal privacy and public health are also very large topics. So unfortunately, given the time that we have, I'll have to manage your expectations by saying that there are significant areas that I will not cover. Indeed, these are, say, covered by experts, for example, Dr. Tan and Charlaine and Dr. Tan as well. So it's crucial that, shall we say, we look at the entire landscape of informed consent and the balance between privacy and public health from a very holistic perspective. This requires us to zoom in to the bedside to see what are the requirements for a doctor to interact with a patient, but also to zoom out and look at the very big picture of personal privacy and public health. It is this zoomed out 30,000 feet helicopter big picture that I seek to maybe share some thoughts with you over the next few minutes. I'll move on to the next slide by saying that the impact of privacy on pandemics have been quite real. And I share some screenshots, and I will not go into great detail, but just to give an idea, a taste really, of how this pandemic has impacted the field of privacy. This picture in the middle is in Korean language. Early on, around March or April, the South Korean government started sending text messages using SMS, similar to the ones that our Majlis Keselamatan Negara will send to us, only that this SMS messages, right, will have a tremendous amount of personal detail that on one hand, the good is people will know exactly who or where they might have been exposed to. But on the other hand, we can also track the locations and the whereabouts and the movements of individual citizens in South Korea. The picture at the bottom shows a statement that was written by several people in the University of Oxford. Why? Because cyber operations by criminals, by state entities, by unscrupulous individuals have begun targeting the healthcare sector, especially because we're collecting so much information. There's been hacking, there's been leaks, and there's been illegal activity surrounding the private information. And the pictures on the right show the various applications. For example, the Arogya Setu in India, the QR codes in China, My Sejahtera in Malaysia, and the Trace Together app in Singapore. These are just 4 examples of movement tracking apps or say contact tracing apps or all sorts of apps really that perhaps are necessary to control a pandemic, but also have an impact on privacy. Allow me to move on to the next slide. And this one's a little busy, and this is intended to give a bit of an overview, really. So I'll spend a bit of time over here before going to my final slide. So this is really my second final slide here, and I'll spend a bit of time over here. The first thing I'll do is to talk about public health security. And here we may have to explain some concepts because perhaps not everybody is familiar with public health. So in the blue box on the left of the screen, we'll look at some terms and definitions. And in the red box on the right of the screen, would look at some very practical implications onto Malaysia as it stands today. Let's first start with the blue box. In the blue box, there are several bullet points. We'll begin with the definition of public health. I won't spend too much time on the definition of public health, but it's nice to just read this so that we can get on the same page. Public health is a science and the art of preventing disease, prolonging life, and promoting health through the organized efforts of society. What I really want to pick on is the idea of organized efforts of society. What that means is public health is too important to be left to doctors alone or to technocrats or to public health physicians. Public health is really, shall we say, a concept, a public good, right? In Malay, we might call it harta awam. That is a responsibility of everybody in Malaysia. And I think it's crucial to consider that public health is not just the responsibility of the Ministry of Health Malaysia or doctors or nurses or paramedics or frontliners. It is everybody's responsibility. We will look at some of the laws during COVID-19, and here I offer three very broad laws. Act 342 is the Prevention and Control of Infectious Diseases Act, and this has been renewed multiple times by the current Minister of Health, and this is the one that gives us the laws concerning the MCO, the conditional MCO, and also the recovery MCO, and various types of MCOs as well. There's a second law that's also impacted, right, in the intersection between health and privacy, health and law, and that's the PDPA, or Act 709. And then thirdly, Act 586, the Private Healthcare Facilities and Services Act, is also a crucial act because it tells you what are the responsibilities of the private sector entities. And as the pandemic in Malaysia shifts away from hospitals and goes towards old age care centers and childcare centers and private healthcare facilities, maybe we might even consider an application on your smartphone is not really an application, because in some countries it is considered a medical device, in which case it comes under the purview of the Medical Device Authority of Malaysia. So as the pandemic increasingly, let me introduce the new term, dehospitalizes or moves away from the hospital and towards the community, then these three laws become very important as we consider how do we secure public health in Malaysia. The third bullet point in the blue box over here is the difference between privacy, personal data, and personally identifiable information. Now, this is something that I think I will leave to our lawyer colleagues in Taylor's University, for example, to sketch out the differences between privacy and personal data and PII. If I were to complicate matters a bit more, it is to say that when you put in confidentiality, which is a bit more of a medical ethics term, then the landscape becomes more complete, but also a little bit more complicated. Finally, I leave you with the thought, very narrowly about public health security, is to talk about the concept of privacy. In the United States of America, privacy is generally considered a consumer right. In Europe, privacy is generally considered a human right. If you consider that this particular distinction, and I'm oversimplifying over here, if it's a consumer right, you will use different consumer laws in order to secure your right to privacy. But if it's a human right, for example, after the Second World War, Germany and the various European countries were very wary about state surveillance. So that's why it's considered a human right. And then they have different laws and different risk appetites to say what's truly important for them in terms of protecting the privacy. Or finally, is privacy a constitutional right? Now, these are increasingly important questions as we consider the public health security of Malaysia. As with all hopefully good lectures, I don't aim to provide answers. I just hope to provide questions that we can all think about, because the answers to these questions are innumerable and all of them are right and wrong at the same time. Let's move to the box in red. In the box in red, these are the specific issues in Malaysia, but I have this big question in my head. Where's the informed consent part? For each of these questions that I'm about to just sketch out for you, I will not provide the answers because every answer is right and wrong at the same time, but merely to sketch out in, say, framework terms, a conceptual understanding, or just a framework of how you can think through some of the specific issues. But as we think through these issues, let's consider where is the informed consent part, because this is the title of today's lecture. The first one is about notification of disease. And here I give you 3 questions. And each of these questions, like I said, have many different answers, and all the answers are right and wrong at the same time. Can we, should we, must we, publicly identify those with COVID, so others will know when to report, avoid the infected, and so on. So for example, the South Korea SMS alerts that I told you about, a fun, if I can use the word fun, I'm sorry for that. A story from South Korea is that people have found out some very unusual factors about their neighbors or their friends based on the very detailed information from the SMS alerts. So the notification of disease is where public health intersects with privacy. And at that intersection, we have three questions. Can we publicly identify? Should we publicly identify? Must we publicly identify? And these are just the principles before you even talk about the operations of how to identify. The second big area is contact tracing, and this is different from notification. Notification means telling people who has the disease. Contact tracing means finding out who are the people that you've been in contact with. For example, the contact tracing for the different clusters of infection that have taken place in Malaysia in various time points and in various physical locations. And then there are subsidiary questions of what data to collect, how to store, how to use, how to protect. Who will collect? When should they collect? Do we collect with apps or using pen and paper in retail outlets? And these are very broad picture questions that I'm providing to all of us. And Malaysia's answer is potentially the best that we can have at the moment. The third specific issue is movement tracking. There are additional issues here of movement bracelets. So beginning, I think it's today, anybody who comes back to Malaysia will be quarantined at home with a movement bracelet. What does that look like? What does that track? But we're not entirely certain. And then there are Bluetooth apps and movement restrictions as well. And finally, if I can, right, in small terms, without going into too much detail, what about privacy in research ethics? Given Malaysia is a part of the World Health Organization's solidarity trials, how are we using big data? What about leaks and sales of data and hacks and use of data for illegal purposes, for example, to shrink the democratic space in Malaysia? Again, I'm merely sketching out the issues for you. We don't have time at the moment to go through what the specific answers are or what the best model would look like for Malaysia, but it's good for us to begin with a conceptual understanding of the issues. In the last few minutes I have left, and this is my final slide, I asked these three questions on the right of the screen in blue, but let's look at the cartoon on the left of the screen, and that is the perennial debate between security and privacy. In any democratic institution, we will always consider security versus privacy as one of the fundamental debates of a democracy. When you consider security and privacy, often security wins. And during this pandemic period, it is possible that in order to assure our own physical security and health, that citizens like you and I are willing or happy, or we accept the trade-offs that we give up some of our privacy in exchange for security. And let me allow me to move on to say a big question. The question of where's the right balance? Because we can't have full privacy, neither can we have full security and no privacy. So there must be some middle ground. And where is that right balance in the middle ground? It depends on very many factors, and I can list out all these factors for you at different time points, at different pandemic time points for even a country like Malaysia. We'll have to adjust where we are in the security privacy continuum as we balance public interest, number one, in terms of public health, and how do we ensure enough accurate information that we can do contact tracing, and therefore requires us to do a risk-benefit calculation. When I say we, I mean all of Malaysia in an all of society effort. The right balance also depends on other things like the social contract, the strength of civil societies, the quality of our current institutions, the quality of checks and balances, and also the awareness levels of citizens. I've used the term citizens, but we can also use different identities. For example, you and I, we're citizens, this is true. We're also consumers. We're also voters, we're also taxpayers, we're also patients, we're also healthcare providers in at least half the conversation today. So the multiple identities that we have in just one setting makes it difficult for us to consider what is it that is the right balance. And I think in that conversation, it needs to continue evolving for Malaysia. I'll ask the second question just to end this conversation, is to say, where is Malaysia now? I would say on balance, we're in a good state in the health, security, and privacy debates. But as the pandemic goes to become more long-term, then we need to be very careful about the privacy elements and not just use the health security elements to continue collecting a lot of information. So as of right now, we're okay, but as we become more long-term and become more community-driven, we have to be careful about the privacy implications. And finally, I leave us with this thought about using COVID, this pandemic, as an opportunity to improve the privacy standards in Malaysia. It took the Second World War to give the United Kingdom the National Health Service, something that they're very proud of. Fortunately, or unfortunately, we have COVID right now, and it's a crisis that we shouldn't waste, especially if we want to improve the levels of privacy in Malaysia in the very long term. This is a national heart attack, in fact, a heart attack for the world that forces us to revisit so many things like the economy, the way we treat frontline workers, and so on, and also how we can improve the standards of privacy in Malaysia. I yield the rest of my time. Thank you for listening.
Thank you, Dr. Khor, our second speaker. Dr. Tan Hui Siu, a pediatrician and bioethicist. Dr. Tan has been a full-time clinician for the past 16 years with administrative and policy-making experiences. As a Yayasan Khazanah Scholar, she holds a Master in Bioethics from Harvard University. She currently concerts her efforts in setting up clinical ethics, support in a public hospital with internal clinical ethical consultation, and interprofessional ethics education. Dr. Tan is also a MREC member. Her areas of interest are public health ethics, clinical ethics, and narrative ethics. Dr. Tan, over to you.
Thank you, Prof. Ambikai and Putri Sophia and Taylor's University for the invitation. I'm really honored to be here. So I think it's kind of exciting to have this topic, so there are many ways to actually talk about it. And I'm glad that, SK has actually covered the bigger picture of the public health and the policy making. So I will just kind of focus on what I think should be the concept of, informed consent that we should strive for, and also the related concept of shared decision making. So you see, I will be illustrating the ethical tensions just at the patient's level, and also the changes that we might get from informed consent. So, and how should we deal about it? So I have no conflict of interest to declare. So given the time constraint, my talk will focus on the patient rather than the surrogates, and more on the clinical type of informed consent rather than, the public health, like just what SK has talked about, the contact tracing app, and again, the ideas and observations I'm sharing here may not represent similarly across all healthcare facilities or institutions. And just to give you the context, like, I'm a clinician, and so I'm coming in today with a kind of more of a clinical ethics perspective. So I'll try to make a point if it's clearly a legal, a clinical, or social, or an ethical point of view, but most of the time they tend to overlap. I have a feeling I might actually just end up giving you more questions than answers today. So you can just relax and allow your mind to wander a bit. So we'll start off with just a case, just an appetizer, kind of thing. So a 45-year-old woman presents to your hospital with a severe asthma attack with suspected COVID-19. So she has agreed to accept treatment, but makes it clear to the ED physician that she does not want to be intubated. So unfortunately, after obtaining an arterial blood gas, performing a physical exam, it is the opinion of the attending emergency physician that intubation is required. So this doctor actually raced over and consults you because you are the legal counsel, you are the legal consult, you are the senior administrative person. So he was asking, what should I do? So that's the informed consent actually comes into the picture here. I think most of you probably get the answer. So, but we'll go on for the next slide. So what does in your mind that an informed consent look like? So this is important to actually kind of trying to define what am I trying to imply where we are talking about informed consent. Is it just signing a consent form? Is it a form to sign once information is being disclosed by the physician or the surgeon? Or is it a back and forth process between the clinician and the patient to ensure that an informed, voluntary, and decisionally capacitated consent is occurred? So for this last part, it seems that, the clinician knows what is best, but he's still asking for an autonomous authorization rather than just conforming to the social rules of consent to have a piece of paper signed. And this should be what we should be striving for. I know, legally it might be not as possible as we think it is, but, okay, so it's as a show of hands, what do you think are the exceptions to having an informed consent? So if Putri, you could just share the poll. It's a multiple choice. You could take one or all, so we just see whether you could just like, with your thoughts about what are the situations where we don't need an informed consent.
Everyone may participate in the poll. The icon is at the bottom of your screen. Thank you.
So this is quite a nice feature from Zoom webinar, and I've been trying to use it as well. So it's quite simple, they don't have much of features, but I think it looks very clear from here. So we have, an incompetent patient. Or are you looking at an emergency, which could be personal, could be public health, or, when the patient actually waived her decision-making rights to somebody else, or, whether you have formed that kind of relationship with the patient, you don't need an informed consent anymore, or is it just a simple intervention, or, part of, the warrant or under arrest, so that's something different. So, let's say if you could just, put in your answers. I'll carry on with the next slide, and hopefully by the end of the next slide, we'll see what other answers are. So I think historically, informed consent, everyone knows that it started off trying to protect the negative rights of patients. So let's go back to history again, and an intrusion of the body should not be done without an agreement. So this comes through, the courts, the English common law, the tort doctrine of negligence that extended to the field of surgery. And, informed consent also came about the same time from the research during the first half of the century, when unethical practice in the Tuskegee Syphilis Project rendered Black men with syphilis without their consent or any treatment. So this is how all, the few areas where informed consent actually came in. So similar to research, the justification of informed consent, I think we know that it includes respect. Reading it out again, a means to harm the interest of the patient, and also to augment trust. But I would like to just invite you, I think we should open our minds also to the expanded notion of, expanded definition of best interest and autonomy. Because we need to think when we say there's an informed consent, there should be an informed refusal as well. So the patient has the right to say no. So it shouldn't be like if they say no, it's not an informed process. It's not that they don't have the capacity. Sometimes we actually tend to say patients are irrational when they say no. Or, when they're allowing a waiver to somebody else if they wish to. So that's the expanded version when you talk about autonomy, you talk about when you talk about informed process. And we need to be mindful also about the influences that affect their voluntariness and their free will, okay? So they need to have some self-trust, they need to have some values, their relational aspects, social determinants, and that relationship that you have with them. So that's the special thing that, you need to actually kind of look beyond just that paper. So let's just go back to the answers. I think we will just end the poll if you don't mind. So, so the answers are, in fact, they are all of the above. So everyone there is actually can be an exception to informed consent. So that's quite interesting. Okay. So so let's go on. So this capacity and voluntariness are what we call the threshold elements. So the preconditions that we need to fulfill before we carry on with disclosure and recommendation. So it's just not two elements that we always look at, disclosure, recommendation, but you need to actually look at the preconditions and without striving for these 7 elements, I think I know it's actually very idealistic, but we may end up having informed consent which are less meaningful. So patients may feel that they are fully responsible for anything that happened, even if it went wrong. Okay, clinicians themselves may be wrongly led into believing that as long as you fully disclose all the relevant options, the burden and the responsibility of that decision will be transferred entirely onto the patient, and that shouldn't be the right way. When it comes to informed consent. So since informed consent involves decision making, so I think it's important that we include the ethical framework and concept of shared decision making, because it's closely linked to informed process of the consent. So what are the difference between, like, informed consent and shared decision making, if you're asking me? So in contrast to informed consent as one activity, most of the time it's one activity that signifies an agreement or refusal to a procedure or intervention. Sometimes we say, okay, uncle, you go back and discuss with your family, then you come back to me the next day. But it's still like one off, one way, one off, with or without a written consent. So in shared decision making, is both parties actually share the information. So the clinicians offer options, they describe their risks and benefits, and the patient expresses his or her preferences and values. Both parties discuss, negotiate, and agree on a decision. And it's not a one-off, it can take many sessions. So this SDM activities in Malaysia actually began around 2010, and a few studies have expressed how patients in Malaysia preferred an autonomous role in decision making as opposed to the paternalistic physician decision making. So, but however, this SDM should be seen as a continuum, because there are occasions that it is ethically acceptable for physician authority to play a heavier role in decision making. Other times, we accept a full range of patient autonomy. So this concept is actually important to understand before we analyze the challenges of informed consent during COVID-19. So you see, there are less shared decision-making moments and less need for an informed consent. Just when we had the question for the exception, you have the simple procedure, okay? Simple procedure. So I would say that it's not simple, but it's probably clear-cut situations where consent are usually implied. You don't need to get, uncle, can I ask your permission to start antibiotics? So I think there are situations where it's very clear-cut. There are one clear superior path, and patient preference actually play a leader role. For example, emergencies, bacterial meningitis when you need antibiotics, or oxygen requirement when the COVID patient actually is having hypoxia. So I think public health emergency, some sees it as that clear-cut, a society need to actually kind of enforce those public health interventions to stop the transmission of the virus. So it can be a clear-cut in a way, but it's up to debate. But for the decision in which no intervention meets that high superior bar, or there are more than one reasonable path, so patients need to be involved in those situations where it's the second group, because it will take their preferences into account of the treatment that they think is consistent with that, So, and the third category is where you have high impact decision like surgery, invasive procedures, medication that can have significant or lasting consequences, not onto his health, but also his life, values. And I think the patient involvement in decision making and a clear informed process is most crucial. So this is the third part. So that's how you look at procedures, you look at interventions, and you make a decision whether you need to actually take an informed consent, you need to have that full informed process. So moving on, moving into COVID-19 era, so we now live and breathe in a strange and unfamiliar environment. So I think the tension that is there, Prof. Ambi has actually kind of touched on it. So what are the challenges when we say, yeah, it's very challenging, so the one thing is like we are having the public health interest as the priority now, and we have medical and health system changing, and it's ongoing changes. Those are the things that bring about the tension where we need to shift a patient-centered approach of clinical care, and now we are going towards a public-centered approach of clinical care. And you'll be wondering, how is it possible to focus on the individual patient and respecting their rights and respecting their preferences when our job now is also to protect the population, the community health. So when we turn to ethics, you say ethics, come on, give us some guide. So the ethical values that has been more or less, it's going to be going back to fairness, is going back to duty to care, duty to steward resources, transparency, proportionality, and accountability. So those are the big words, the key, the key ethical values to set guidance in crisis. But again, how do we navigate through the more specific, challenging decision making that rarely have a single right answer? So you talk about how do we anticipate and respond to clinical care where we are more COVID-19 focused now? How do we redefine our standard of care? Can clinicians keep up to date, fast, and accurately enough? And can they live up to the expectations of performing at their usual best when it's a whole new world? So patients have less choices. They are definitely more anxious and they are so much confused in the new system. So how can we help them? Today, we're not going to answer those questions, but at least that is going to give you a broad picture of where the ethical dilemmas are before we zoom into the changes in informed consent. So you see my slide on the changes is not much there. So I'm going to end soon. So first, there will be more implied consent during COVID-19 pandemic. I think this is actually kind of a logical, observation, and it doesn't need an expert to tell you that. So, but this problematic change is itself an ethical need. Okay, so some say is, this is what we need because crisis management, you need to move in a swift and orderly fashion to halt the transmission of the virus. So is that a justified exception to informed consent? So yes, our lives are intertwined and our public health interests are individual health interests. So that's where public health interests are the individual health interests also. So this kind of consensus paternalism, I'll call it as that, has been touted as an ethical requirement to ensure that everyone is safe. So you might disagree with it, we can discuss more about that. So when you have that standardized SOPs now, on infection control procedures, mitigation plans for mobilizing and decanting clinical service, it becomes the driving force of having more implied consent. So the ethics group has observed that we have a compromised patient autonomy now and less SDM process. Is informed consent still relevant when you can't refuse? Is there any meaning to SDM when you can no longer honor individual patients' values and preferences, and you can't afford to disclose all the options that you used to do? So, like alternative treatment, second opinion, transfer of care. So eventually the $1 million question is going to be, so where are the clinical, legal, social, and ethical boundaries? So do clinicians and public health officers really know what they're doing and how far they should be pushing when autonomy is already compromised? So we think about where are the areas where we can actually allow some shared decision-making process. So then we think about how to go about this scenario. So I just listed out a few scenarios, it might have been your questions, about like a patient with end-stage COPD who has previously refused for any ICU care but currently diagnosed with COVID and needs to be intubated, or the young man without the COVID, but he has a very complicated medical illness. He's at the university hospital. Now he needs to be decanted to a secondary hospital because the university hospital is now a COVID-19 hospital. Or what about the patients that are going for operation? Do they need to be tested every single time when they go for op? So therefore, at some point we need to reconsider to have some shared decision-making for some scenarios, informed consent, informed process, in which the procedures have remained restrictive, the evidence for it remains lacking. So I'm listing this out here, but they are not exclusive, they are not comprehensive. The arguments are not conclusive yet, but it's for us to just think about it. Okay, so for example, I'm a pediatrician. So we have these issues, the distress that we are facing, separating and disallowing breastfeeding for newborns born to mothers with or suspected COVID. So even for mothers that doesn't have any, I think this distress came the most from the private sector. So when we think about it, should a mother be informed on the risks and benefits according to the latest evidence and actually be allowed to visit or hold the newborn if she insisted?
Dr. Tan,
COVID-19?
Dr. Tan, I'm sorry, I think I may have to interrupt and stop you here. Probably you should just finish off the last two lines.
So this is actually kind of the last slide. So this is the yes, where you need to have what are the situations that we might want to. So this is the no, where we say, no, we are not going to have it. But in the end of the day, you need to think about like, is it ethically just? Or you need to have some compensatory measures. So I've listed out the compensatory measures that you might want to think about when you have a compromised autonomy. You need to keep them very well informed. You need to have good communication. You must make sure that you are actually doing something which is evidence-based, rather than saying, just because of the public health law that you need to follow. So this is where we need to think about, like, when we say no and yes. So I think that's all. so thank you very much.
Thank you.
Yes.
Thank you, Dr. Tan. Sorry for interrupting you. Perhaps we can have another session face-to-face in campus once the
Yes.
MCO is totally lifted. Huh? Okay, yes, thank you so much. We shall now move on to listen to the legal perspective from Ms. Charlaine Adrienne Chin, a partner with Messrs. Darryl and Low. I would introduce Ms. Charlaine first. Upon being admitted to the Bar of England and Wales in 2010 as a member of the Honourable Society of Middle Temple in the UK, Ms. Charlaine undertook a stint at DiaLAWgues Chambers in Hong Kong. Subsequently, she read in chambers with Mrs. Darryl and Law and was called to the High Court of Malaya in 2012 and is currently a partner in the dispute resolution team with the said Messrs. Darryl and Law's dispute resolution practice group, which is now currently ranked as Tier 1 by the Asia Pacific Legal 500 in its 2020 ranking. Ms. Charlaine's practice focuses on civil and commercial litigation. The bulk of her practice thus far has been in respect of medical legal cases, where she has represented medical practitioners accused of clinical malpractice in civil suits and disciplinary inquiries led by the Malaysian Medical Council. Ms. Charlaine was part of the team that was involved in the host of landmark medical negligence appeals to the federal court, which were reported in late 2017 and 2018. Apart from that, Ms. Charlaine also conducts trials and appeals at various levels of Malaysian courts in respect of tortious and contractual claims involving, among others, sale of goods, banking, and professional negligence. Ms. Charlaine.
Thank you very much, Dr. Ambi. Thank you, Taylor. Thank you, Putri, as well, for the invitation. And to my fellow panelists, what an honor. Right. Let me start by addressing actually the first question that Dr. Tan had raised in her presentation, and then her final question as well. The first question was, she talked about what consent was, right? And I think she hit the nail directly on the head. It really, from a legal perspective, it goes to the heart of patient autonomy. Right? It is a consensus or the meeting of the minds of a patient and a doctor before a very crucial decision is made. So that was the first question that she asked. Now, the last question, and I think perhaps the interesting question and the thread or the theme for today would be, where do we draw these lines between, what's legal, what's ethical, what's right, what's logical? Now, from a legal practitioner's perspective, we say that legal and ethical issues, they definitely are distinct, but it doesn't mean that they're incompatible, right? So what's legal is what the law prescribes as within the boundaries of what's permitted. And when you talk about what's ethical, it would be, more about what's fair and things of that sort. We talked briefly about the consequences. If you do something that's illegal, you will be brought to face the court. If you do something that's unethical, for example, for a medical practitioner, you then face the Malaysian Medical Council, right? So the consequences are quite different. But having said that, while they are distinct, I think the important point is that they ought to be traveling on a parallel road. They ought to be consistent, so to speak. All right, now, so I will just briefly touch about the legal perspective. Let me just pull up my slides very quickly. So the first box here, you see, it is to negate a claim of trespass to the person, or if you talk about criminal law, it is to negate the crime of battery, right? And we always hear this, the issue of consent being discussed together with the duty to advise of risk. Now, strictly speaking, from a legal point of view, they actually are distinct and different, actually. But the reason why they always sort of discussed together is because they come almost hand in hand, right? You advise of the risk, you advise of the options, and then you obtain consent. But strictly speaking, they are to actually address different legal causes of action. Now, as I said earlier on, consent, trespass to the person, and battery. When you talk about the advice of risks, the duty here is one under the tort of negligence. So that is actually to negate a claim in negligence. That's just a very strict distinction, okay? But I thought it's important to make that clear. Right, now moving to the next slide. Okay, now how much should a patient know? So the law says that the patient must be informed of the broad terms of the nature of the procedure, which is intended. Okay. Now, these are the exact same words used by the courts in Malaysia, in Australia, in the UK as well. So it's consistent more across the Commonwealth jurisdictions. Okay. Now, just informing the patient of the broad terms may not necessarily be enough, because the patient needs to understand and actually comprehend what the doctor is saying. I think that's quite basic, right? So the question we often ask is, now, must consent be in writing for it to be valid? So the question then is, it's broken up into two, right? Firstly, you talk about the validity of the consent. Now, a consent is valid from a legal perspective if you meet the legal threshold. The legal threshold, as I mentioned earlier, is if you advise the patient of the broad terms of the procedure. So if you've advised of the broad terms, we say the consent is valid, right? But I think the second part of the question, must every single consent be in writing? Ideally, yes, but not necessarily, right? Because we've got these various types of consent. So number one, you've got express consent, right? It can be verbal, it can be written, it can be communicated to you in different ways. That's express. It's very clear. Yes, I agree. And then you've also got implied consent. For example, if a doctor were to give a patient an injection, and the patient then just comes to the doctor and puts out his arm, that's implied. He may not necessarily say, yes, I agree to being injected, but by virtue of the patient's conduct, it can be implied that consent is given. And then you've got non-verbal. Non-verbal may be written, for example, okay, but as it is non-verbal, right? So there's many different types. And then there's just this portion here which I want to highlight, emergencies. We had a very interesting poll earlier on about what are the exceptions to consent. And I think one of the exceptions legally recognized is in terms of emergencies. So when there's a medical emergency, consent can be dispensed with, provided that the patient is not able to consent, right? If, for example, the patient is still aware, but it is an emergency situation, we would actually advise the doctor to sort of, tell the patient what's going on and try and obtain consent. But even if the patient does not, there is case law to suggest that emergencies would be an exception. All right. So if we say that not all written consent needs to be in written form, then why do we even bother with written consent? If you look at the MMC guidelines, they repeat over and over again. You listen to lawyers, they keep telling you, please make sure you document. So why? Now, there's several reasons, but I just like to highlight the important ones first. Firstly, it's good medical practice, right? It's always good to document what happens. And that leads me on to the second point. Because in the court of law, and even in the inquiries before the MMC, what we always see is that it's always the doctor's word against the patient, right? What happens is there'll be an adverse outcome, the patient will complain or sue the doctor, and the patient comes and says, you never told me this. If you had told me this, there's no way I would have agreed. And the doctor will be like, of course I did. I do that as part of my practice. I've been practicing for X amount of years, and I do that all the time, and in any event, I would not have continued if you had not consented. So we always find this he says, she says situation, which then leads us on to the third gear, contemporaneous document. So what happens when you have polarizing views, or rather opposite views between the patient and the medical practitioner? You want to give the decision maker, whoever that person may be, something ideally that's contemporaneous. So when we talk about contemporaneous, it is a document that's created at the material time. And what would be those documents? It would be your clinical notes, the nursing notes, the consent form as well, right? So it's good then to have something in writing. And that's the reason why we always tell doctors to document what's important, not just the consent, the advice of risks, the questions perhaps that the patient may ask, the pertinent questions, and any other significant finding. Yeah. Right. So now in this current age where, the pandemic has really brought us indoors and onto the virtual platform, we've seen a rise, although not new, we've seen a rise with virtual consultations. So let's just take a look a little bit at the physical consultation versus virtual consultations in respect of obtaining consent. Yeah. Okay, there we go. First, we talk about the limitations, all right, for virtual consultations. Now, you know, in a virtual consultation, just like how we are on now, non-verbal cues may be less obvious. For example, if I'm sitting far away or if the lighting is not very good, you may not necessarily see certain facial expressions I may have, or you know, you don't see the patient. For example, if your video cam is just under here, you don't see anything else. You don't see if the patient is fidgeting, things of that sort. And then you've also got connectivity and communication issues, right? In certain areas, the internet connection may not be as good. Your virtual consultation may be interrupted along the way. Right? A lot of doctors also, we find they like to use images or documents to supplement the process of obtaining consent. And when you go on virtual consultation, that becomes a little bit harder, right? And fourthly, there isn't actually a hard copy form to sign. So then what then happens? Now, overcoming the obstacles, this is what we suggest. Of course, by no means exhaustive. But it's always good to check whether the patient is able to hear clearly. So before you start your virtual consultation, you check with the patient, you know, Mr. So-and-so, can you hear me? Is it clear? Okay, and you make it clear that, you know, should they have any questions at any time, raise it with me. And then when you talk about the advising or the explanation of the broad nature, that's what's required for valid consent. It's always good practice, and I think particularly so when you're doing it virtually, to sort of ask the patient to repeat or describe in their own words, right? That's how you know whether the patient actually understands. So a lot of times we get queried by doctors, you know, they say, how am I supposed to read the patient's mind? You know, they're in front of me, they're nodding their head, but then later on they come back and they have a complaint. It's usually like that. Hindsight is 20/20. So what's a good thing is to actually ask the patient to say, you know, do you understand? Can you then just repeat to me what is it that, you know, you understand from our discussion? Or how would you describe the procedure that I would be doing, you know, on you? Things like that. Okay. And then I think the third point is also very important. A lot of doctors, I think, feel that because of the current situation, the virtual way is the only way to go. That isn't true, right? You always have the option to not proceed with a virtual consultation and then ask the patient to come in for a physical consultation. Who would be the best judge of that? It would be the doctor. So always be guided by your clinical judgment, and if in doubt, always err on the side of caution, right? And then the final thing, which is our mantra for lawyers, please record or document the consent in one shape or form. So for example, if the patient agrees to the virtual consultation being recorded, then record it. That would be great. If not, then you can write in your own notes that, you know, patient consented, explain this, patient agreed to do X, Y, Z. Yeah. Now moving on, a lot of people ask us this, is an e-consent form valid? Now this question actually has two parts. So when you talk about the consent per se, right, it would be valid if you've explained the broad nature of the procedure to the patient and if the patient has actually understood. If you're talking about the consent form in electronic form, the consent in electronic form, then the answer is also yes, it will be admissible in court, but of course under the applicable rules of evidence. I don't propose to go through that in length now, but that's just broadly the position. So there's no need to worry about, you know, not actually having a hard copy of the consent form. And my final slide is this. So when we think about consent, I just want us to think about 3 C's. The first is communication. You have to advise the patient of the broad terms of the nature. That's the legal requirement. That's the legal test. Should a claim be brought against you in the court of law, and the allegation is that you didn't get my consent, that's the legal test you need to satisfy. And then the second C is comprehension, right? You must make sure that the patient understands and agrees. And just very quickly, the classic example where the court has actually illustrated the importance of a patient's comprehension was this. The patient went in, she underwent a hysterectomy, okay? Obtained consent, advised of risk, hysterectomy was carried out, uneventful, post-op recovery, also uneventful. After she recovered, she came back to the gynae and she asked the gynae this in the first consultation. All right, doc, so tell me, when can I start having kids again? And of course, the doctor was like, oh my goodness, I just carried out hysterectomy. So obviously in this case, and it was actually the decision of the court, a finding of fact that the patient didn't understand what was communicated to her. So comprehension, very important. And finally, corroboration. Please document, document, document in any form. It can be, if it's just a one-way documentation, it's still documentation nonetheless. If the patient, of course, agrees to, sign a consent form, at this point, I think it's important for me to sort of point out, and as Dr. Tan had also said, merely going through a checklist of a standard form doesn't necessarily make it valid. Yeah, you actually have to go through, explain, and the patient must understand. And when there is that consensus of the mind, and when there is a genuine agreement, that's when you have real consent. So I think that's all from me. Thank you very much.
Thank you, Ms. Charlaine. We shall now move on to our final speaker for today, Dr. Patrick Tan Seow Koon. He's an anesthesiologist and specialist in intensive care medicine. Dr. Patrick graduated with an MBBS from the Royal London Hospital, which is London University, in 1980. As an anesthesiologist from the Royal College of Anaesthetists in 1986, and as a fellow critical care medicine at the University of Pittsburgh Medical Center in 1996, and as an intensivist with EDIC in 1999. He's a retired professor of anesthesia and intensive care and a former coordinator, medical ethics and personal professional development with University of Malaya, Faculty of Medicine. He's a fellow of the Academy of Medicine Malaysia, a medical advisor to the Medical Protection Society, a member of the World Health Organization, World Alliance for Patient Safety, founder member of Acute Kidney Injury Network, past president of College of Anaesthesiologists, and has served as a secretary, vice president, and president of the Asia Pacific Association of Critical Care Medicine. His areas of expertise are intensive care medicine, ventilation, infectious disease and outcomes, anesthesiology for pediatric anesthesia, transplantation anesthesia, hepatobiliary anesthesia, medical ethics, and medical informatics. His recent publications include journal contributions to Lancet, New England Medical Journal, Intensive Care Medical, Crit Care Medical, and Respiratory Critical Care Medical and Pediatrics Journal. He is an active researcher and has received Excellent Service Award from University of Malaya in 2005 and 2008, Excellent Service Certificate from University of Malaya in 2003 and 2004, and his journal contribution on the Nipah virus was recognized as the most cited publication in the university in 2007. His area of research is on mechanical ventilation, acute lung injury, Nipah virus, and circulatory arrest. Doctor, over to you.
Chairman, thank you for your introduction. Thank you to Taylors and to Putri for your invitation to speak today. Good afternoon. Thank you very, very much. Now, in this lecture, I shall cover our present landscape, which are the rules of medical confidentiality, and try to detail how we can comply in our areas of practice. So when a patient sees a doctor, the patient expects a professional relationship, the doctor-patient relationship. And this aims to be fulfilled in law as a duty of care and in ethics by the four principles of respect, beneficence, non-maleficence, and justice. A doctor's desire to improve patient welfare to obtain a beneficial outcome is a moral idea which, when carried out, results in a good consequence. This is consequentialist ethics. Information that the patient discloses to a doctor is much more than just the name and contact details. It's the whole physical state, the mental state, the biologic circumstances, and the identity. And these are details which society is not privileged to know, but are privileged to a doctor. So a patient invests profound trust in the entire healthcare system. And confidentiality is central to the preservation of trust between doctors and their patients. Continuing trust strengthens the system for all who practice and all who have access to medical care. A bond of trust between the doctor and the patient forms the strongest professional relationship between society and the healthcare system. Preservation of confidentiality is necessary to secure public health, and failure to maintain trust through respecting confidentiality may result in suboptimal treatment. Personal information is confidential if it has the quality of confidence, is imparted in circumstances implying an obligation of confidence, requires the person's permission to be disclosed to a third party, is not in the public domain, and is in the public interest to protect it. Information that has been revealed or divulged by a patient to a doctor through verbal conversation, physical examination, any other evidence which forms a diagnosis, treatment, or prognostic plan, and which identifies the individual, is confidential. Doctors have upheld the confidentiality principle. This is written down in certain rules. In the Hippocratic Oath, I will keep secret and never reveal the secrets that have been disclosed to me by my patients. In the Declaration of Geneva, I will respect the secrets even after the patient has died. And in the Malaysian Medical Council Code of Professional Conduct, the registered medical practitioner is responsible and must ensure that the information is protected against improper disclosure. Doctors have to consider the benefits of breaching patient confidence against the harmful consequences of damaging the professional relationship and losing public trust in a confidential service. Now, in terms of absoluteness, medical confidentiality is not absolute. There are exceptions, legitimate exceptions to absolute confidentiality. These are disclosure with consent, disclosure required by law, and disclosure in the public interest. There could be inadvertent breach of confidential information, such as when medical notes are left visible or when a doctor-patient consultation is conducted in an open environment. There may be unintentional breach of confidential information through the use of non-encrypted services for communication, email, social networking, or via non-encrypted personal computers and tablets which contain personal information, because we know that passwords can be bypassed. Another example is when operation theatre lists have been discarded without using a paper shredder. And we should be aware that images taken under implicit consent of organs, specimens, slides, or radiography are subject to confidentiality if identifiable. Now, disclosure with patient consent is the usual way to go. If a patient expressly consents to disclosure, a doctor is relieved from the duty of confidence. And this consent may be obtained explicitly or implied. Explicit consent requires an active agreement of the patient that is either verbal or written. And it also requires an understanding of the capacity to consent, which means that the patient comprehends and balances the information and is able to communicate their desire. All of these may not apply in critical illness with a patient who is sedated or has impaired thought or is unconscious. Disclosure may be justified on the presumption of implied consent where consent is undesirable or not possible, such as in the previous example. And when this is done, the decision-making should be on the basis of acting in the best interest of the patient. In other jurisdictions, There may be certain persons who are officially appointed to receive this disclosed information, such as an independent mental capacity advocate, a power of attorney, or a court-appointed deputy for healthcare decision-making. There are a few other examples for justified disclosure, perhaps too many to be described individually. I've summarized them here on this slide, and I will just read them by each line. In the case of multidisciplinary healthcare teams, it is recognized that this should be obligatory for optimal care. Where there is disclosure for audit reasons, the information should be anonymized. Where disclosure is desired for research and for publications, there has to be explicit signed consent. For disclosure for families and interested parties, it can be considered by the healthcare giver, the doctor, if it is in the patient's overall best interest. For employers, insurance companies, and lawyers, the doctors are required to provide the information, but must provide honest, substantiated information. There is no penalty for a breach for statutory disclosure, but it requires a court order. And in certain jurisdictions, mature children have the right to privacy and protection from their parents. So this needs to be taken into consideration when performing a disclosure. Disclosures in the public interest can range from public health to the prevention or detection of serious crime. And we recognize that there is subjectivity, and the decision may in some instances have to be made by courts. We should remember that in the public interest is not what the public or media are interested in. Public health, we have the Act 342, and in this, we recognize that there will be circumstances where disclosure outweighs the benefits of personal privacy. And this act requires doctors to disclose epidemiologic information by compulsory reporting of specific communicable disease. If possible, the patient must be given the opportunity to consent before the disclosure is made. What about disclosure after death? Ideally, the ethical duty of confidence persists after the patient's death. In communicable disease, information on death certification can be made available to the public. And in this, doctors are required to give full and honest disclosure. The Personal Data Protection Act is a framework to govern the process of information which identifies living persons, including health records, and sets minimum standards for the ownership of personal data and privileged use. These are the personal data principles that they should be processed fairly and obtained only for lawful purpose, be adequate and not excessive, be accurate and up to date, not kept longer than necessary, and processed in accordance with the rights of data subjects. There should be technical organizational protection against unauthorized or unlawful processing, and it should not be transferred to a territory outside unless there is adequate protection. Lastly, in many medical specialties, a trainee logbook is mandatory in higher professional training, and information needs to be accurate, sufficient, with details that will enable education supervisor to verify. It is possible to provide just sufficient information for verification while arguably preserving some data protection. Doctors are advised to register as individual PDPA users, to have authorization from the medical education establishment, and to obtain the patient's explicit verbal or written consent. Malaysia does not have a Freedom of Information Act which permits public authorities to have access to healthcare data. In Act 709, PDPA, personal data, information on the physical or mental health of a subject shall be exempted from the access principle. In summary, maintaining confidentiality underpins public trust in the healthcare system, including medical professionals. Legitimate exceptions to absolute confidentiality are disclosure with consent, disclosure required by law, and disclosure in the public interest. And doctors should safeguard the handling of patient data and comply with the PDPA. Thank you very much.
Thank you, Dato Doctor. So perhaps now we can move on to the question and answer session. And we shall share the screen for the question. Right, we have quite a bit of questions. I hope we could try and address most of it if time permits. Probably we will take questions which are much relevant to the current situation, which is COVID-19, because I think that is the dilemma that we all are in today. So maybe the experts here, the panelists here can help us to look at these questions and see how your thoughts and your ideas would help us handle this current situation. So for example, the question here, there's a special question here for Dr. Tan. Can you comment on the need for informed consent versus assent in clinical research involving children who has autism? Dr. Tan?
Thanks for the question. It's going to be research ethics, and I think we have clear guidelines, I think in the university or even from, you know, the MREC, where if you have children, so they are considered as vulnerable. So most of the time they would need a parental consent. So I would say it's not consent, but parental permission plus an assent from the child, if the child is able to kind of read, or, you know, so it can't be a toddler, you know, so it should be like a 10-year-old. So you have a different, where you get his or her assent on, you know, on top of the parental permission or consent from the parents. So, you know, so that works with for children, whether they are autistic or, you know, whether they have any other children. So it goes by, because children overall, they have that mental capacity which is still developing, autonomy which is still developing. So it, you know, because of that, compared to an adult 22-year-old with autism. So that's another question where they might not have the capacity to actually sign on and inform consent. So that's where, you know, the surrogate decision maker, you know, someone need to sign on behalf. Thank you.
Yeah, I hope that has answered the question, whoever has posed the question earlier on. There is another question here from Ms. Charlaine. Could you elaborate, what does it mean by broad term of procedure? How does it relate to the materiality of the risk of a procedure?
Right. What does it mean by broad terms of the procedure? That phrase isn't defined in case law. I think the medical practitioner will have to make a clinical judgment. In your view, what would you say is the broad nature of the procedure? It basically means a description of the procedure in broad terms. I'm using the same words. So I don't think there is a hard and fast rule. There isn't anything in black and white. It's something that I think that it's a general description. You don't have to go into the description so detailed, and certainly try to avoid medical jargon. So for example, if you're talking about hysterectomy, you might want to avoid using the word hysterectomy, or even if you say, you might want to say, I am going to remove your womb, for example, okay? And then the second question is, how does it relate to the materiality of risks of a procedure? How is it related? The answer is that the conversation usually happens at about the same time, because when you talk about the procedure, you then talk about the risks. But as I mentioned earlier on, they are separate duties and distinct principles. Consent is to negate a claim in battery or trespass to the person, whereas the advice of risks, where you have to advise the patient of what's material, you mentioned the word materiality, that's the key word, that's to have a defense should you be sued for the tort of negligence. Yeah, and on this point, Dr. Ambi, is it okay if I just take the question on top there, because it's related? It talks about
yes, sure. Is a standard consent form sufficient? Is that what you're talking about?
Yeah.
Yes, go ahead, please.
So that one is related in the sense that, is a standard form sufficient? It depends. If you are relying on the form merely as, you're just going to tell the patient, have a read of this, tell me if you're agreeable, that's not going to be enough. Because your duty calls you to act beyond that. You have to explain what is the broad nature. And then if the patient agrees, decide. But if your consent form, for example, has a list of a specific list of a particular procedure, and you go through that list, so it's sort of a facilitative role, there's nothing wrong with that. But relying on the consent form without giving thought to what is said, that's where the danger lies. Yeah, I think that's all.
Okay, thank you, Ms. Charlaine. I hope that has answered the question. Any more questions? Ms. Putri, maybe we can go on to the first questions. Right. In the situation of COVID-19 patient who the heart suddenly stopped, will the doctor resuscitate him or not? What if he has DNR order earlier? What is the best for him? Probably Dato Doctor Patrick, would you like to take the question? We have not directed to any specific panelists.
Thank you very much for this question. Clearly, I think it is very difficult, but I think the doctors will always do their best and assume that the patient will need to have a chance, be given a chance, and the doctor will have to do whatever they can to resuscitate the patient, even whether or not they have COVID. That's the first thing. If the patient has a DNR order earlier, then this is something that requires balanced judgment by the doctors looking after. Hopefully there will be a senior person around with experience to weigh up whether the person's DNR needs to be carried out or whether the decision to DNR should be reversed. It is very difficult to know which is the best for him because this is very contextual. It depends on the circumstances and it depends on some other inputs which may or may not be present, such as the immediate wishes of the family and other things that may have changed in the person's immediate clinical condition before the cardiac arrest. I hope that answers the question.
Thank you, Doctor. Probably I would direct this question to Dr. Khor. Is telemedicine, I saw a question, Putri, maybe you want to project the question. Telemedicine Act 1997 is not sufficient to protect practitioners and clients, nor regulate telemedicine, yet we are promoting it. What is your opinion on this? Probably Dr. Khor, you could address this question.
Thank you. It's a really broad question, so maybe I'll address it in two sets of comments. The first set of comments is to say that it is true, the Telemedicine Act is good on paper and it's quite, shall we say, rhetorical, but it's not yet implementable, as in it's not good enough for us to rely upon, for us to have any form of telemedicine. So often it's very aspirational in terms of what, shall we say, the healthcare leaders or the private sector might say. It's important for us to consider how telemedicine can be part of the post-COVID future, reliance on health tourism for Southeast Asia. So patients from Indonesia, for example, might not need to come to Malaysia for us to continue giving that kind of care for them. This is true, but the regulations are probably not yet set up. It feels a little aspirational to me rather than technically feasible at the moment. Those are my initial thoughts about this. But secondly, it may be also necessary for the industry to consider some form of self-regulation. So what I mean to say is, although the Act itself needs to be updated in the first instance, where we need to beef it up and be more specific and put in the privacy implications, the implications of confidentiality, data protection, and so on and so forth to make it feasible from the government side, it's possible that the private sector can consider self-regulating or creating standards for themselves in advance of the government's legislative agenda. And when I say the government, I'm thinking Malaysia as a start. And let's talk about, shall we say, if we broaden the conversation a little bit to include health tourism, then maybe ASEAN will need to take a bit of the lead as well. What I mean to say in the second set of comments is it could be a little bit more the private sector taking the self-regulatory leadership in terms of telemedicine. So those are my two sets of comments. Thank you, Ambi.
Right, thank you. I have a comment and a question by Dr. Stephen. I think it is the right person that I'm thinking of. His comment is, in my practice, I'm fine. Informed consent is not being done. I'm fine if informed consent is not being done in a proper way in elective situations, leave alone in the emergency situation. Now, what more in a pandemic situation? And that is his, I think, his take on this. And he has also posed a question. My question would be to you is, take consent. Do you take consent for intubation or take it as part of treatment you are giving and just explain to patient or relative and proceed? Shall I direct it to Dr. Patrick?
As I read, thank you very much, Dr. Stephen. As I read the question, it seems to me actually there are two parts of saying pretty much the same thing. When we are about to do something to the patient, we should always explain it and try to get an understanding of what they comprehend and whether they agree to allow us to do it. And if they don't, we have to try harder, or we have to explain an alternative method to the patient. I think the second part of the question, to proceed as part of the treatment, I think is a little bit insecure and perhaps incomplete.
Okay, I hope Dr. Stephen, you have got your clarification on that. Right, there's another question here. If suspected COVID-19 person is not giving consent to quarantine him, what to do? Right, so if patient with COVID not giving consent to get admitted, what to do? So there's two situations here. Dr. Tan, would you like to handle that?
I think it's kind of fit into Dr. Stephen's question also. So you have suspected COVID patient not giving consent to quarantine him, what to do if a patient with COVID not giving consent to get admitted, what to do. So we definitely have the second part, the scenarios where we are having now. So the first part is, I think, the quarantine. Quarantine, when we say that, quarantine means that you have not been confirmed, but it's better that you just like stay away from the rest. And so if the Minister of Health or, the Minister has says that, we are going to do this, you need to follow, because that's the public health law that is ongoing, that you can't, you can't go against. So in that sense, we are not getting a consent. So the one thing that usually they sign is probably not an informed consent where, there's risk, benefits, and you're going to consent to the procedure. So that is really, something which is, first thing, he cannot refuse. And the second is just that, that piece of paper he's signing is different from what we think about what informed consent should be. So, but we do have some of the patients which are maybe elderly, terminally ill, and they have signed an advanced care plan, like, I'm not going to get intubated anymore, and I've been in and out of ICU, and now I'm COVID positive, and I don't want to get admitted. So the one thing about whether we should honor him, and the second, whether it's actually kind of reversible kind of process where, once you get intubated, a few days time you get recovered, so there's an intensive, you say, no, let's give him a chance. We should just intubate him and get him over COVID, he'll be thankful, and, then he can get on with his end of life care and whatever. But you have also that part where the risk of transmission to others, so that you cannot defy, you cannot say that, I want to go back home. So I think that being admitted, it fulfills two reasons. One is for treatment, the other one is actually to isolate him so that he doesn't transmit the virus to others. So you need to look into whether what are we talking now. So I hope I don't create more questions.
But in this situation, could we just resort to the Prevention of Infectious Control Disease Act in order to govern this situation? Because anyway, the law prevails, isn't it, over ethical considerations of applying patient autonomy here, that he doesn't want to be admitted or quarantined, right?
Yeah, so that's the thing about Western countries where their autonomy is like, number one, you know, and they are defying, you know, the rules of public health interests and regulations, and you get into trouble of not controlling the whole pandemic. So you have that imperative to actually kind of follow. But from the ethical point of view, we'll be saying that if it's the benefits are there and you're not pushing too hard on autonomy, and whether how can you compensate where he doesn't have the autonomy, because what we find that patients get to be quarantined, isolated, but not knowing what's going on. And that's not right. You know, you at least they have the right to know what's going on. Communication is ongoing. They have all the information, even though they know that they have no right to actually refuse because of the law. But you know, there's always that part where we need to think about, are we doing the right thing? Because there are a few procedures which we think we might be too restrictive. I think Prof. Patrick would probably can talk about a few areas
Yes,
where a bit too restrictive.
Dr.
Yeah.
Patrick, you would like to add on to that?
Did you hear me? Yes, all right. So if there is no consent, I think we will, well, let's try and see whether the patient can have any measure of understanding, comprehension, and with regard to bringing them up to date with the situation. And if they're really not able to give that consent, as we understand it, then I think we have to take a consensus, again, have a senior level specialist give some advice. Okay, now we need to get him admitted and we have to apply the law and to get him admitted. I think that would be a last resort to proceed without really getting the patient's active consent, because we would have to get implied consent.
Dr. Ambi, can I just interject?
Yes, sure.
With respect, I think the contrary view actually, the right to compel a person to either be screened or to be quarantined, to undergo treatment, immunization, or isolation are the words used in the Act, is actually enshrined in sections 11 and 15 of the Prevention and Control of Infectious Diseases Act. And there is an express provision which is codified under section 12, which makes it a statutory offense to go against an order directing you or an individual to undergo either surveillance or observation, or in this case, a quarantine. So quite frankly, I think from a legal perspective, I agree entirely that the patient should understand why they're being directed to do a certain thing. But the question as to whether or not consent is required is quite redundant, because the law compels you and that right is enshrined. And the law then, I guess Parliament has gone a step further to say, not only should you obey, but if you don't, it then becomes a statutory offense. So I think in this particular situation, I think quite frankly, the right is enshrined under the law. But of course, by all means, I'm not saying that, we do a hard and fast rule where sort of like no questions asked, you are thrown into quarantine. Not that way, of course. But the right is under the law. And I think consent in this particular case isn't a question, I think. Yeah.
Okay.
Can I just say something?
Yes,
yes. I agree with what Charlaine says, that the law is right and we have to comply. But I think doctors will try and think further down the road, because the next day we may come across something else that we need the person's consent, and we still need to have that degree of understanding and cooperation. So that's what I'm getting at. We will try hardest until we really can't, and then we will apply the law.
Thank you, Dato. Thank you, Charlaine. Probably we'll take, as time is running out, probably we'll take one last question here posed to Ms. Charlaine. It is important to note that the Telemedicine Act is not in force yet. The MMC has, in about March-April 2020, issued guidelines on virtual consultations titled Advisory on Virtual Consultation During COVID-19 Pandemic.
That was a comment I made actually, because I think...
you made a comment. Sorry. I read it as a question. Okay. I'm sorry. Okay, that's why I was wondering, where is the question? Okay. All right. So since it was a comment, okay, probably you'll take one more question. Okay, there is a question here. If a patient for repetitive treatment like could you just move down a little bit? I'm done with that. Okay, hi. Okay, it is said that during pandemic, there is no emergency. Can doctors be taken legal action for not treating patients earlier, like during the non-pandemic time? I mean, but I think this question is a little bit, I don't know, very general. I mean, what do you mean by treating for what during the non-pandemic time?
Can we ask the person to clarify why they say that?
Yeah. Could you please clarify this? It is said during,
emergency.
He might be talking about resuscitation.
I see.
Yeah, but because treating for what, he or she is not very clear with what is he or she is asking. Okay, probably Ms. Charlaine, I think there are a few questions here for you. The CDC is there, but there are many SOPs when carrying out. Any thought on false imprisonment in that matter?
Sorry, what is the context of that question asked?
I just don't know what is the context. Okay, it's probably not very clear. All right, maybe we'll take this question. Do you think we need new laws for consent for pandemic situation like COVID? I think it's from Dr. Stephen.
Okay, so do we need new laws for consent for a pandemic situation? I would say perhaps not. I think the laws are malleable enough to address the situation even when there's a pandemic, because they have kept it broad enough to cater for a myriad of situations, but at the same time, if I may use this word, specific enough, or rather with enough precision and clarity for doctors to still be guided as they go through the pandemic. So in my view, I think as things currently stand, that's it. That's in respect of advising broad terms of the nature. I still think that's okay. I think we have to be very careful with how we deal with situations. I see a lot of the word of emergencies here. Now, the Ministry of Health, the MMC, and even the courts have made it very clear in their own particular documents that when it comes to an emergency, consent can be dispensed with, right? What a doctor does is you go in, you do the best you can in the patient's interest, and of course, you get a consensus of another medical practitioner. That's obvious. And then consent will then come in situations apart from emergencies. So the long and short of it, I think the laws we currently have are sufficient. I just think that, you know, it shouldn't be a blanket provision. We should always look at the facts of the case, depending on the circumstances in that particular patient.
Okay, thank you, Charlaine. Okay, I think we have come to the end of the session. All right, I would like to thank the panelists here for your very useful and wonderful insights, for sharing your experiences as well as what's happening in the current situation during this COVID-19. Thank you so much for your time and your contribution. On behalf of Taylor's University, I would like to extend my sincere appreciation. There's no tea provided. We can have a glass of virtual tea. All right. Oh, thank you so much. Over to you, Putri.
Thank you so much again, Dr. Ambi, for moderating this session. And again, on behalf of Taylor's Law School, as well as the head of Taylor's Law School, Mr. Hamahinder Singh, I would like to personally thank you, Charlaine, Dr. Patrick Tan, Dr. Tan, as well as Dr. Khor Swee, for your time to share your insights as well as perspective with regards to the topic that we have today. And also, we would like to thank all participants who are here with us to listen to the insights shared by all the distinguished panelists. All right, thank you so much, everyone.
Thank you.
Thank you. Take care. Have a good afternoon. Hope to see all of you again.